Hello everyone, welcome back to Juris Veda. So, today we are going to study one of the most important topics in constitutional law, that is the features of Indian Constitution. Now, we all know that the Constitution is the supreme law of our country, but what exactly makes the Indian Constitution different from other constitutions? Why is it described as federal but at the same time having strong unitary features? Why do we say that it is both rigid and flexible? And where did some of these features actually come from? So, in today's video, we are going to look at all of that in a very simple way. We are going to go slide by slide and I'll explain each feature along the way. So, let's get started. What makes it distinct? Now, the first question is what actually makes the Indian Constitution distinct? First of all, the Constitution of India is the supreme law of the land. That basically means that every law and every exercise of governmental power has to operate within the framework of the Constitution. Our Constitution is a very detailed written Constitution. It brings together things like fundamental rights, fundamental duties, democratic institutions, and principles of governance within one constitutional framework. Now, an important date to remember is 26th November 1949. That is the day on which the Constituent Assembly adopted the Constitution. Adopted the Constituent Adopted the Constitution on 26th November 1949. Then, okay, but it came into force on 26th January 1950. And that is why we celebrate 26th January as Republic Day. Now, another interesting feature is that the Indian Constitution is one of the world's longest written national constitution. It currently has 25 parts and 12 schedules with numerous articles and amendments. And finally, you may have heard the expression bag of borrowings. Don't take that expression negatively. It simply means that the framers studied different constitutional systems around the world and adapted several of their features to suit Indian conditions. So that is basically what makes our constitution distinct. I hope that is clear. Now let's move on to the historical origin of the constitution. Okay. So, this slide gives us a very brief timeline of how we arrived at the Constitution. The first important point here is 1928, the Nehru Report. The Nehru Report was, one second, okay. The Nehru Report was an important early Indian constitutional proposal and included proposals relating to fundamental rights and the structure of the government. Okay. Then we come to 9th December 1946. This was the first sitting of the Constituent Assembly, and Dr. Sachidananda Sinha as served as the interim chairman of the Constituent Assembly. Then we come to 29th August 1947. On this date, the drafting committee was constituted with Dr. B.R. Ambedkar as its chairman. The drafting committee played a very important role in preparing the constitutional text. Okay, and then finally we come to 26 November 1949. The constitution was adopted by the Constituent Assembly, and as we just discussed, it came into force on 26 January 1950. So these are some of the important dates that we should remember when studying the making of the constitution. Now let's look at the major structural features of our constitution. Okay. Core structural features. Now we come to one of the most important slides. The first feature is the length of the constitution. Originally, the constitution had 395 articles, 22 parts, and 8 schedules. Over time, amendments and constitutional developments have expanded its structure. The next feature is the federal system with strong unitary features. India has a division of powers between the union and states. We have the union list, state list, and concurrent list. But at the same time, the constitution gives considerable strength to the union. For example, we have a single constitution and single citizenship, and residuary powers are vested in the union. So, India is federal, but it is not a classic federation where the states are completely autonomous from the center. Now, then we have parliamentary form of government. The executive is drawn from and responsible to the legislature. The president is the constitutional head, while the council of ministers, headed by the prime minister, plays the central role in the functioning of the union executive. And finally, we have the blend of rigidity and flexibility. Our constitution is neither completely rigid nor completely flexible. Different constitutional provisions can be amended through different procedures. Some can be changed by simple majority, some require a special majority, and certain federal provisions require a special majority along with ratification by at least half of the states. So that is why we describe our constitution as a combination of rigidity and flexibility. Okay, so now that we understand the basic structure, let's move on to the three very important constitutional components, that is rights, directives, and duties. Okay, now the slide is extremely important because it covers three major parts of the constitution. First, we have fundamental rights under part 3, articles 12 to 35. These are justiciable rights. In simple words, they can be enforced through codes. They include rights relating to equality, freedom, protection against exploitation, freedom of religion, cultural and educational rights, and constitutional remedies. So, these rights primarily protect individuals against unconstitutional state action. Okay. Then we have directive principles of state policy under Part 4, Article 36 to 51. Unlike fundamental rights, you cannot normally approach a court simply to demand the enforcement of a directive principle. But they are extremely important because they provide guidelines and objectives for the state, particularly in relation to social and economic justice and the welfare of the people. And then we have fundamental duties. The fundamental duties comes under Part 4A, Article 51A. Okay. The fundamental duties were originally introduced by the 42nd Amendment in 1976, and the 11th fundamental duty was added by the 86th Amendment in 2002. These duties include respecting the Constitution, protecting the environment, promoting harmony, and several other civic responsibilities. So, if we look at these three together, we can say that the Constitution not only gives us rights, but it also provides guidelines for the state and duties for citizens. Okay, that's an important point to remember. Let's move on to some of the democratic and judicial features. Okay. Mhm. So the first feature on the slide is the secular state. India does not have an official state religion, and the constitution guarantees freedom of conscience and religion subject to constitutional limitations. The word secular was specifically inserted into the preamble by the 42nd constitutional amendment in 1976. Okay. Now next we have universal adult franchise. Today, every citizen who is 18 years or above is generally entitled to vote, subject to the constitutional and statutory qualifications and disqualifications. This is an extremely important feature of Indian democracy because voting rights are not based on factors such as caste, religion, sex, or economic status. Okay, then we have single citizenship. Unlike some federal systems, India provides for single citizenship for the entire country. Then comes the independent and integrated judiciary. India has a single integrated judicial system headed by the Supreme Court. Okay, headed by the Supreme Court. The constitutional structure also provides safeguards intended to preserve judicial independence. And then finally, we have independent constitutional bodies. For example, the Election Commission, the Controller and Auditor General, and the UPSC. Okay, these institutions have constitutional status and constitutional safeguards relating to their functions and independence. So these are the features that help support democratic governance and the rule of law. Now let's move to something very important, the emergency provisions. Okay. So now this is one of the most interesting features of the Indian Constitution. The emergency provisions are contained in Part 18, Articles 352 to 360. Okay. These provisions allow the constitutional system to respond to exceptional situations and can significantly strengthen the authority of the union. There are three main types of emergency. The first is national emergency under Article 352. A national emergency can be proclaimed on the grounds of war, external aggression, or armed rebellion. Now, this is where we need to be slightly careful. A national emergency does not simply mean that all fundamental rights disappear. Article 358 and 359 does not simply mean that all the Article 358 and 359 deal with the effect of an emergency on fundamental rights. Article 358 specifically deals with Article 19 in the constitutionally specified circumstances, while Article 359 deals with the suspension of the right to move courts for enforcement of specified fundamental rights. And Article 20 and 21 cannot be suspended under Article 359. So that's an important distinction. Now we have precedence rule under Article 356. This applies when the government of a state cannot be carried on in accordance with the constitution. In such a situation, the president may assume certain state functions and the parliament may exercise the powers of the state legislature, subject to constitutional scheme. Finally, we have financial emergency. Under Article 360, this may be proclaimed when the financial stability or credit of India or any part of its territory is threatened. During such an emergency, constitutional provisions allow measures affecting financial matters, including certain salaries and financial legislation of the states. So, these are the three types of emergency provision. Now, let's move to one of the most commonly discussed features of Indian Constitution, that is its borrowed provisions. Okay. So the borrowed from the world. Now, this is where the expression bag of borrowings become relevant. The framers of Indian Constitution did not, one second. Okay. The framers of Indian Constitution did not simply copy one constitution. They studied different constitutional systems and adopted or adapted several features according to Indian requirements. Let's quickly look at some of them, like from the UK, United Kingdom. We have features such as the parliamentary system, rule of law, single citizenship, cabinet system, and bicameralism. Then from the United States, we have fundamental rights, judicial review, independence of the judiciary, the concept of a preamble, impeachment of the president, and the office of the vice president. From Ireland, we borrowed the directive principles of state policy or DPSP aspects of the method of election of the president and nomination of members to Rajya Sabha. From Canada, we get the idea of a federation with a strong center, residuary power with the union, and appointment of governors by the center. Now, from Australia, we have features such as the concurrent list, freedom of trade and commerce, and joint sitting of the two houses of the parliament. Okay, from Germany, emergency related provisions concerning fundamental rights were influenced. Okay. Now, from the USSR, the idea of fundamental duties and certain ideas relating to social and economic justice were influenced. Okay, from South Africa, we have aspects relating to the constitutional amendment procedure and election of Rajya Sabha members. And finally, we come to France. We have the ideals of liberty, equality, and fraternity. So, as you can see, the Indian Constitution has drawn from several constitutional experiences. But the important thing is that these provisions were adapted to the Indian conditions. So, it is not simply a collection of copied provisions. It is a constitutional framework designed specifically for India. Now, let's look at some numbers relating to the Constitution. Okay, the Constitution in numbers. Now, this slide gives us a quick numerical picture of the Constitution. The Constitution originally had 395 articles, 22 parts, and 8 schedules. Today, we commonly refer to it as having 448 articles, 25 parts, and 12 schedules. Okay, and the Constitution has evolved through constitutional amendments. As of now, there have been 106 constitutional amendment acts, with the 106th amendment enacted in 2023. So, when we call the Constitution a living and evolving document, this is one of the reasons. It has been amended and adapted over time to respond to changing constitutional, political, and social requirements. But there is an important limitation. The Supreme Court has held through the basic structure doctrine that Parliament's power to amend the Constitution is not unlimited. So, while the Constitution can be amended, its basic structure cannot be destroyed. And that brings us to our final slide. That is the key takeaway. So, let's quickly recap what we have studied today. The Indian Constitution is one of the world's longest written national constitution. It has a federal structure with strong unitary features. It follows a parliamentary form of government. It combines rigidity and flexibility in its amendment procedures. It guarantees fundamental rights, lays down directive principles, and imposes fundamental duties. It provides for secularism, universal adult franchise, single citizenship, and an independent judiciary. It also contains detailed emergency provisions. And finally, it incorporates several features inspired by other constitutional systems while adapting them to Indian conditions. Okay, so these are the major features that make the Indian constitution both unique and distinct. And with that, we come to the end of today's session. I hope this video helped you understand the major features of Indian Constitution in a simple and structured manner. If you found this video useful, don't forget to like, share, and subscribe to Juris Veda for more videos on constitutional law and other legal concepts. So, thank you for watching. I'll see you in the next video. Bye.